Under the Republic Act 7875, the filing of claim must be done within 60 days upon the discharge of the patient. Now, kapag hindi sila nakapag-claim and then inalter nila yung period of confinement ng patient, for them, para pumasok sila sa prescriptive period ng filing of claim, it will constitute post-dating of confinement period which is punishable under or which constitutes a fraudulent act punishable under the Republic Act 7875. Number 5 is the misinterpretation by furnishing false or incorrect information. Definition is that any healthcare provider shall be liable when it furnishes false or incorrect information as required by the law. These offenses includes but not limited to the following acts involving benefit claims. These acts are code substitution, which refers to the claiming for unrelated illness or procedure with higher benefit payment in lieu of actual illness or procedure or to be able to qualify for reimbursement. Second is that adding a non-existing condition. C is that making it appear that the patient suffered from a compensable illness or underwent a compensable procedure. Fabrication and or possession of fabricated forms and supportive documents. Any healthcare provider who is found preparing claims, reports, and or health-related data with misinterpretations or false entries, or to be in possession of claim forms, reports with health-related data without authority. Now, question, what if the member was found in possession of? Is the member liable for fabrication and or possession of fabricated forms and documents? The answer would be depends. Generally, no. He will not be liable because as defined under this act that any healthcare provider yung liable dito. However, if the member is proven to be in connivance with the healthcare provider, then the member will be liable, and we will tackle more of that in the offenses committed by members. Okay, we proceed to other fraudulent acts. Any healthcare provider who performs an act that deviates from the normal procedure and is undertaken for personal gain, resulting thereafter to damage and prejudice to the National Health Insurance Program, which will be capable of pecuniary estimation. Now, as defined, overbilling refers to any healthcare provider who charges patients which are above or beyond what is necessary or reasonable. Okay, question. What if the patient was charged below what is necessary? Can the health facility be liable for overbilling? The answer is, of course, no, because as overbilling provides above and beyond. However, papasok siya sa other unethical acts which we will discuss later. Okay? Second is the upcasing, upcoding, diagnosis creeping, or procedure creeping. It defines that any health care provider shall be liable when it files a claim which has higher severity or complexity or to gain higher benefit payment. Third is recruitment practice. Dito naman, any healthcare provider who engages in solicitation of patients by any means or any form or through any medium shall include but not limited to the following: medical missions in which a healthcare provider has directly or indirectly entered into a contract or any agreement and or linked up or tied up with a non-government organization or an institution in guise for charity. However, the sole purpose is to solicit Philhealth patients. Medical missions limited to Philhealth members and their beneficiaries only, punishable po yan. Medical missions primarily done for the purpose of profit gain which do not promote the best interest of the patient or the National Health Insurance Program. Number 4 is harboring ghost patients. Ghost patients, meaning patients which are dead, fictitious, in order for them to claim under the program. And tandaan, either intentionally or unintentionally. Meaning, if the healthcare provider is negligent or it is intentional for such healthcare provider na mag-include ng patient which is dead, fictitious, the healthcare provider may be liable for harboring ghost patients. Fifth is refusal to admit and or provide appropriate service. Kapag nag-refuse si healthcare provider to admit provide patient without any justifiable causes, such healthcare provider may be liable to refusal to admit and or provide appropriate service punishable under this act. No? Other unethical acts or violation of code of ethics. Dito naman, any healthcare provider who performs an act which are contrary to the code of ethics. For the violation of code of ethics or professional code of ethics as to professional healthcare provider and other analogous acts which put or tends to put disrepute the integrity and effective implementation of the National Health Insurance Program. Now, let's proceed to abuse of authority. The following acts are filing of multiple claims. Any healthcare provider who files 2 or more claims, reports, and other related data for patient who has been confined or underwent outpatient treatment once but was made to appear as having been confined or undergone such treatment 2 or more times and or for 2 or more different illness for the same confinement or outpatient treatment. Meaning, si patient, under the name of the patient, 2 claims or 2 or more claims were filed even though in reality, such patient underwent only 1 treatment. Now, second is the non-compliance with co-payment or co-payment policy. Now, ano po yung co-payment or co-payment policy? Co-payment policy refers to a predetermined rate paid at a point of service program. Now, yung point of service program refers to a program which covers all Filipinos under the National Health Insurance Program, including the unregistered and inactive registered members. Now, the no co-payment provides that unregistered or inactive registered members must not pay prior for them to avail any point of service program. Under the breach of warranties of accreditation, any healthcare provider who commits any breach of such warranties will be liable under the abuse of authority. Now, for a health facility or a professional to be a partner under the National Health Insurance Program, they are subject to accreditation. And violation of such accreditation or performance commitment will constitute a breach, which ultimately is deemed to be an abuse of authority under this act. Number 4 is unauthorized procedures beyond service capability. Dito, si healthcare facility performs procedures which is not within its authorized capability. Generally, however, meron po tayong exception. In case of emergency to save lives or which the referral to a facility with sustainable capability is physically impossible. Yun lang po yung exempting circumstances for a healthcare facility to be absolved of its liability under the unauthorized procedures beyond service capability. Next is other unauthorized acts. Any healthcare provider who performs any other acts that go beyond what is authorized by the Universal Healthcare Act and the Republic Act 7875. Now let's go to the penalties. Fraudulent acts, unethical acts, and abuse of authority committed by healthcare providers as defined shall be penalized syempre after due notice and hearing with a fine of 200,000 per count or suspension of contract up to 3 months or the remaining period of its contract or accreditation whichever is shorter. Or both, just like the revised penal code, Republic Act 7875 provides mitigating, aggravating, and similar circumstances which may affect the gravity of the violation and the liability of the erring healthcare provider. However, limited lang po siya. Sa mitigating circumstances natin, provides only voluntary admission of guilt, good track record, and first offense. The aggravating circumstances, on the other hand, first is previous conviction of an offense as provided in these rules, connivance and or conspiracy to facilitate the commission of a violation, and gross negligence. Other similar circumstances naman, this may aggravate or mitigate the liability of the healthcare provider. Next is the rules in criminal case and filing of criminal case and civil case. No? Meaning, not only that the healthcare provider is administratively liable under this act, he or she or it may be criminally liable, which is punishable by 6 months and 1 day up to 6 years of imprisonment. Also, the filing of such will not bar or will not affect the criminal liability of the defendant or of the accused under the revised penal code. And the filing of those cases will not preclude the PhilHealth from filing a separate civil action against the erring healthcare provider. Okay, let's proceed to offenses committed by members. Punishable acts are the following. No? Any member who commit any violation under this act failed to pay all missed contributions with interest compounded monthly, or knowingly and deliberately cooperate or agree, whether explicitly or implicitly, to the commission of any violation by a contracted healthcare provider or employee or employer as defined in this section, including the filing of fraudulent claims or for benefits or entitlement under this act. Ito po yung sagot sa tanong natin kanina na what if yung member possession of files containing misinterpretations or false entries. Dito siya mafo-fall sa third act if proven, no, that the member intentionally cooperates or agrees, expressed man yan or implied, to conspire a violation or any violation with the employer or healthcare provider. Proceed. Now, okay, offenses committed by employers are the following: failure or refusal to deduct contributions, failure or refusal to accurately and timely remit contributions, failure or refusal to submit reports, and also unlawful deductions. Question: what if an employer fails to deduct contributions unintentional? The intention for him to fail to submit reports. Will that employer be liable under the offenses committed by employers? The answer is no. It must be deliberately or through inexcusable negligence. Take note, inexcusable negligence, meaning mere negligence will not make the employer liable. Okay. Next, offenses committed by PhilHealth directors, officers, or employees without prior authority or contrary to the provisions of this act or its implementing rules and regulations, wrongfully receives or keeps funds or property payable or deliverable to the PhilHealth, and who appropriates and applies such fund or property for personal use. In short, misappropriation of funds. Second is that the directors, officers, or employees commits an unethical act, abuse of authority, or performs a fraudulent act as provided kanina sa discussion natin. Take note that the same shall also constitute a criminal violation punishable by imprisonment of 6 months and 1 day up to 6 years upon the discretion of the court without prejudice to the criminal liability defined under the revised penal code. Meaning, administratively liable plus criminally liable. See PhilHealth director, officers, or employees. Okay. All other violations involving funds of PhilHealth shall be governed by the applicable provisions of the revised penal code or other laws. As you can see, under the revised penal code, related provisions or the crimes committed by public officers, included dito yung malversation of public funds, and under the Republic Act 3019 or the Anti-Graft and Corrupt Practices Act, as well as the Code of Conduct and Ethical Standards for Public Officials or the Republic Act 6713. Okay, question. What if si healthcare provider pinailan siya ng case under this act, no? For example, abuse of authority. However, the healthcare provider stops its operation. He ceased to operate. What will be the effect of such cessation of operation? What will be the effect in the case?